My name is Megan Crane, and I'm a gift officer with the Providence Foundations of Oregon. Thank you again for being with us today. I'm really excited for our presentation on estate planning essentials with Emily Hogan. This presentation is really designed to encourage you to create an estate plan or review an existing plan that you may have in place. So we really hope that this is of service to you and your family as you consider all the options that are available to you. Before our speaker, I want to share a few resources with you that may help you with your planning. First, I briefly want to share about the Providence Foundations of Oregon. Many of you participating in today's webinar are generous donors to Providence, and we're exceptionally grateful for your commitment. Without your support, we would not be able to meet the critical health needs of our communities around the state. Gifts from donors help Providence provide quality health care, implement critical community programs, and conduct world-class research. Some specific examples of this include support of behavioral health programs, senior health, emergency medicine, patient support programs, children's health, grief support for children and adolescents, and truly hundreds and hundreds of other crucial programs around the state. Many donors also choose to include Providence in their estate plan. Later in her presentation, Emily will provide some ideas of how a charitable gift to Providence in your will or trust can best benefit you, your loved ones, and mitigate your tax liability, all while supporting health and wellness in our community. If you're interested in learning more after today's webinar, I'm here to provide personalized giving information and be a resource in your planning process. I also want to share with you that our office provides a free estate planning guide, which helps put all your assets, loved ones, and goals in one place. It's a really great tool to aid in your estate planning process. And if you're interested in receiving a digital or hard copy of the guide, please email me at megan.crane@providence.org. So without further ado, today I have the honor to introduce Emily Hogan of Fitzwater Law. Emily's practice emphasizes all areas of estate planning and administration. She particularly enjoys helping young families establish an estate plan. Emily believes in working with clients to create a customized, detailed, realistic, and clear estate plan, which will accomplish their wishes. Emily aims to provide peace of mind and clarity for her clients while also giving them the information necessary to make well-informed decisions regarding taxes, charitable gifts, distributions, and trustee options. Emily grew up in Idaho and received her undergraduate degree at the University of Pennsylvania and went on to receive her JD from the University of Oregon. As a reminder, you can submit questions to Emily throughout the presentation using the Q&A function at the bottom of your screen. And with that, thank you, Emily, for being with us today.
Thanks, Megan. Welcome, everybody. I will hopefully be able to get through a good portion of my materials today in less than the hour, because I know that a lot of times these presentations bring up a lot of questions, and hopefully, just like Megan said, you guys can go ahead and put questions that you have in the Q&A function, and I'll be able to get to those as many as I can during this hour, but I do want to be respectful of your time. So if there's something that I don't get to, I will have my email address at the end of the presentation, and you're more than welcome to email me and ask me any questions that you might have. As Megan said, my name is Emily. I've been doing estate planning here in Oregon for a number of years. I do lots of these presentations. I really like kind of the group atmosphere to get some basic information across. And then, like I said, I'm happy to answer some more specific personal questions afterwards. For estate planning, I tell clients that really there's 3 items that we need to check off our list. There's powers of attorney for finances, there's medical directives, and then there's the main estate planning vehicle. So I thought when I was putting together this presentation today, I went ahead and kind of focused on those first 2 in the beginning and get those out of the way so that we can really focus more of our attention on the main estate planning vehicle and tax considerations and charitable giving and things like that. So you'll see on the next slide that I talk about incapacity, and that covers kind of the first 2 pieces of that estate planning package. I tell clients there's the things they should think about. There's a financial incapacity question, and then there's a healthcare or physical incapacity question. And the two documents that cover those, well, I guess I should say 3 documents. The one that you can prepare preventatively so that somebody can take over for you to manage your finances is called a durable power of attorney. And that's confusing because in a lot of places there's a power of attorney for finances and a power of attorney for healthcare. I'm focusing on the financial one. And for that second, health incapacity or physical incapacity, that's covered by usually an advanced directive that talks about your healthcare wishes about long-term care, life support, those kinds of things. And then the PULSE form. And we're going to talk about both of those as well. Without either of those documents or any of those documents, the way that somebody could take over for you if you were incapacitated is through a court. And you do that with a guardianship, which is over your person, talks about healthcare and where you want to live, those types of things. And with a conservatorship, which is over finances. And those both have to come through a court. Next slide talks about power of attorney for finances. So this is the one where if you were incapacitated, meaning based on a doctor's evaluation, you can't manage your own finances. Red flags might be paying bills multiple times, maybe not paying bills, all of those kinds of things. Then we create a power of attorney. And it's basically a preventative document or a preemptively prepared document that says, I'm appointing this other person as my agent, and that person has my permission to step into my shoes as if they were me and conduct financial business. So that allows somebody to continue to pay your bills, to pay your mortgage, to talk to your bank. If you have a retirement account, it allows them to talk to that company and maybe take early distributions, even if there are tax consequences, to pay for those things. The important thing about a power of attorney is it's only valid during your lifetime. Once you die, it becomes invalid, kind of like a social security number. And that's where the main estate planning vehicle takes over and the person that you've named there. Within a power of attorney, they can be very broad or very narrow. I've seen ones that are narrow enough that they're for a specific time period, like while I'm traveling in this other country. I've seen them be very broad. I've seen them say things like, you can only access my funds to pay for my bills. And I've seen other ones that say, you can access my funds to make gifts to family members as long as they're consistent with my established pattern of gifting, to change beneficiary designations, to pay any bills you want, to write checks to anyone you want. I've seen them very narrow and I've seen them very broad. Things that you want to consider when you're working with an attorney to prepare one is, can your agent make gifts? And are those only to individuals? And if so, who? Or are they also including charitable gifts? If you have a pattern of an established gift that you make every year, then that might be something that you want your agent to continue to gift, because there might be tax purposes behind it, but also charitable benefits. Ability to use funds for spouse or partner, ability to update beneficiary designations. Those are all kind of things that you want to think about when you're working with an attorney to prepare these powers of attorney. And again, they have to be done and signed before you have incapacity issues. Next slide talks about the advanced directive. So this is the document that deals with, preemptively deals with incapacity in terms of your health care. So you are allowed to name a healthcare representative, somebody who has the ability to talk to your doctor, discuss your healthcare considerations, all the things that normally would be covered under HIPAA. And then you have the ability to make some end-of-life decisions about life support, about tube feeding. The newest advanced directive, by the way, that advanced directive form does get updated every couple of years. And so the newest one has kind of what I call multiple choice questions about what type of life support and tube feeding and things you want. But then it also has what I call open-ended or essay questions, short answer questions, where you write in what things are most valuable to you in your life. What are your spiritual beliefs? Those types of questions. Hand in hand with the advanced directive, on the next slide, I talk about the PULSE form. And this is the physician's order for life-sustaining treatment. This is one that you can distinguish between two, because this one is much shorter. It's only one page and it's bright pink. And it's the one that you fill out with your doctor. You can't do it in your attorney's office. And it talks about resuscitation, serious progressive illnesses, available medical treatments, if and when you want those, and those types of things. So lots of people have both the advanced directive and the pulsed. It's not necessarily an either or, but they do work in kind of different situations and pertain to different treatments, different situations. So it's something that you definitely want to talk through with your attorney and talk through with your primary care physician as well. So that kind of takes the first two off the board of how do we plan for incapacity, and whether that's financial or otherwise, and what documents can we have preemptively. The other big piece of this is, what vehicle are we going to use to transfer our assets from us or me individually to whomever I want to benefit after I've passed away? And what I tell people is, think about three options when you're looking at those vehicles. One is to have no estate planning documents at all. The downside, of course, is lack of control, and everybody loves control. But if you don't have it, it doesn't necessarily mean, and lots of people think this, that if you die, all of your things escheat to the state. That's not how it works. What happens if you don't have a will or a trust or any other estate planning vehicle is, first we look at how did you own assets. And if you owned them in a way that passes them directly to somebody, then we follow that path, right? So if you and your spouse own a house together and you pass away, that passes to your spouse, depending on how the deed reads. And if you have a life insurance account or a retirement account, life insurance policy or a retirement account, those assets name a beneficiary directly. So if you've named your child or your sibling or your parent or whomever it is as your beneficiary, those assets will pass directly. And the other assets that you own that don't have a joint owner or a beneficiary designation, those assets would go to probate. And probate really is the legal term for the courtroom process to distribute your assets. Touching on that lack of control piece, without any documents at all, you don't get to say who's going to be your executor or your personal representative. How are those assets going to be distributed? Who's going to receive them? Those things are all set by the court and by the statutes that contribute to probate. So those you don't get control over, but you do get control, you don't get control, but you do get to know in advance where your things will go. Those are set by statutes. So they go to spouses and then kids and things like that. Avoiding unintended estate distribution. If you don't have any documents at all and a person passes away, the court controls, like I said, that distribution, how it happens, where it goes, and we call this intestate succession. So for some people, if it's a married couple that has two joint children, maybe the intestate succession laws do represent your wishes. But if it's somebody who's outside of that model, it's a blended family. If you have minor children, you might not want them to receive assets at 18. If you're unmarried partners, if you have something going to a close friend, if you want to gift to charities, all of these other considerations make you maybe outside of that initial model. And so intestate estate planning is not always the best option. Sometimes people opt for a will. And what a will does is send your assets to probate, but maintains the control. Next slide. The next slide talks about probate. So my rule of thumb for probate is $4,000 and up in dollars. And that's because every time the court requests something, you have to do something for the court, you usually have to pay some sort of fee or cost for the court to review that. My time frame is 4 to 5 months and up. That's because it's a 4-month minimum for a court. What happens is I submit something to the court and say, this person has passed away. Here's their death certificate. Here's their will. And then that starts a 4-month time clock from tolling. And what happens during that 4 months is your executor, your personal representative, jump through a number of hoops that the court wants. And one of those hoops is opening it up and receiving creditor claims, right? So we publish notification that this person has passed away, and that triggers anybody who is owed something by that person to come forward and say, I need my debt paid off. The nice thing is at the end of that 4-month period, the creditor claim period gets cut off. So the court says no distribution for those first 4 months because we might have some outstanding bills we don't know about. But after that, there is some benefit to your executor because that creditor claim period is cut off and they're no longer worried about potential creditors that are out there. There are a number of what I said hoops that your executor has to jump through. Those include things like publishing notification of the decedent's death, that creditor claim period, taking a class at the courthouse that teaches you how to be an executor or a personal representative. And by the way, I'm using those terms interchangeably because most people know the term executor, but in Oregon, we use the term personal representative. So I kind of tend to jump back and forth so you can follow me, just so you know the Oregon term is personal representative. Sometimes wills waive the ability for a personal representative to be bonded. Sometimes they don't. So those are all kind of considerations of probate. In the will, for a will to be valid when it goes through probate, there are some requirements, right? There are some execution requirements signed by the person, presence of 2 witnesses, the person is legal age, sound mind, not under undue influence or duress or fraud. Some basic just formalities. And those are the first thing that the court's going to look at. Is this a valid will? Was it validly executed? Next slide. The will then goes on to pull that power back in, right? No estate planning documents, probate with no power. Will, probate, but with power. And the will can say things like who's going to be my personal representative, right? Who's in charge? If you don't have that, it's who comes first to the courthouse. It can name a guardian if you have minor children. If both my spouse and I have predeceased, our kids are going to live with so-and-so and what that's going to look like. If you also have minor children, it can prepare what we call testamentary trusts for them that say things like, if my spouse and I have both passed away, here's who my kids will live with. And I don't want my kids to get money at age 18. I want them to get money at age 25. But in the meantime, I want to name a trustee who can use that money in advance for their education and healthcare or whatever it is. So you can make those testamentary trusts as strict or as broad as you want as well. Providing for dependents or other relatives that maybe aren't good with money or are receiving means-tested benefits. That's a benefit that you're not allowed when you don't have estate planning documents. They can incorporate tax planning. That's a really big one. We're going to talk a lot more about that in just a few slides, but tax planning federally can be an issue, but not for most people. But tax planning in Oregon can be a very major issue. Wills are less expensive than a trust, and wills allow you to give outside of the intestate succession plan that's set by statutes, right? So no documents at all, your things go according to intestate succession. But with a will, you have the ability to give gifts to friends, other family members, maybe give charitable gifts, do a lot more planning. A lot more options are available to you than would be if you don't have documents at all. Go ahead and go to the next slide. So we've talked about no documents and lack of power and probate. We've talked about wills and probate, but with some power and abilities. The other option is to create a trust. And I tell people to think about a trust as a giant fishbowl. And the fishbowl is really just the document I create. And then you have the added responsibility of putting your assets into the bowl. So your assets become the fish and the fish go into the fishbowl. So for instance, if you owned a house, creating a trust means you also need to redeed your house to be owned by the trust. and you would go to your banks where you have bank accounts and you would retitle those to be in the name of the trust. So it's a significant amount of more work than a will would be. But here's the huge benefit of a trust. When you pass away and your personal representative or your heirs say, okay, we need to submit this to probate because she owns some assets, I get to say, no, he or she didn't actually own any assets because the entity that they created owned them all. They're all titled in the trust name. So we don't actually have to open a probate, and none of that entire courtroom process has to be accomplished. Instead, the trust itself names a trustee, and the trustee's job is to pay your outstanding debts and expenses and taxes, and then go ahead and distribute those funds. So while a trust is more expensive and more kind of burdensome in terms of the things that you need to do, your to-do list, it saves your heirs a lot of time and money down the road because you get to avoid probate. Now, that is only the case if everything gets done correctly, right? If you create a trust, pay the money for it, and do the work to fund a house and your bank accounts and all those things, and it's all neat and pretty, and then in 10 years, you open up a new account at Bank of America, and you forget to put that account into your trust name, and you own it in your name individually. If you pass away, all of the things in the fishbowl pass to the beneficiaries by trustee, but that one account at Bank of America would need to go through probate all on its own. So trusts have a lot of benefits, but only if you're very diligent about making sure that all the fish get added to the fishbowl. Again, with the requirements for execution, signed by the settlor, having capacity, usually there's a notary signature. It goes into effect immediately. So this is different from a will, right? A will is valid and existing, but doesn't actually go into effect until after you've passed away. Whereas a trust, as soon as you transfer those titles, a trust owns your assets right then. And it has preferences for how those funds get spent or used by you during your lifetime, or if you're incapacitated, how they get used for your benefit during your lifetime. The trustee is in charge. The trustee is usually you creating the trust, and then you name successor trustees as well. Within the trust, it can provide for dependents if they aren't able to manage their financial affairs, or minor children, right? Similar to a will, we can do testamentary trust situation of, I want my assets to pass to my kids, but they don't have access until they're 25 type of situation. It can incorporate estate tax planning. Again, we're going to talk about that in just a second. You can give some detailed instructions about long-term care because it goes into effect immediately, unlike the will. The long-term care issue can be addressed through the trust, whereas with a will, you couldn't do that because it doesn't actually have any effect until after you passed away. A trust is a really attractive option if you're someone who owns assets in multiple states. So for instance, somebody who has a house lives here in Oregon and has a house, but also has a house in California or a house in Hawaii or whatever it is. If you were to pass away, not only do we need to do an Oregon probate, but we also need to do a Hawaii probate for the real property that's owned over there. And so a lot of times for those individuals, a trust is really attractive because you can deed the Oregon property and the Hawaii property into the trust, and then there's no probate in either of those places. A trust is more expensive than a will. A lot of people care about cost a lot, and they think about it in terms of two issues, right? Cost upfront now. What does it cost for the attorney to prepare the will versus prepare the trust? And cost down the road, right? Neither one has any annual fee or anything like that. But if the trust is funded correctly, then it's just the trustee doing administration. Whereas with a will, you're paying the probate fees down the road. And so there's kind of a balancing act that you need to consider there of what makes the most sense for your individual situation. Go ahead and go to the next slide. So this is an important piece of the whole planning bigger picture. And I bring it up, I've already brought it up one time, but I want to bring it up again because there are assets that are not included in my discussion of no planning documents or will or trust, right? Those are for a lot of assets, but there are assets that are kind of in a fourth box over on the side, which are assets that have a designation or a way of passing on their own. So I think before I mentioned if you and your spouse own a house jointly, or if you and your child are co-owners on a bank account, or if you have a retirement account that names a primary and a contingent beneficiary, same with life insurance. Those are assets that can be over in this fourth box that pass directly to the joint owner or the named beneficiary without you having to do will or trust. Now, it's a rare situation where I would say all of your assets are in the fourth box. Don't worry about having anything. Most of the time I would say, let's aim to get all the assets in the fourth box, but let's have a very simple will prepared as a safety net so that if there's, if there's concerns, or if somebody makes claims of incapacity, or if you have a lot of tangible items, that we have a document that guarantees the passage the way you want it to be. Hopefully we don't have to use it, but I'd like to have it there and created just in case something goes unaccording to plan. Let's see, go ahead and go to the next slide. So this is kind of the visual representation. TOD, POD, transfer on death assets, go directly to the beneficiary, joint owners, trusts, and sole ownership that goes to probate. So in looking at your assets, and this is where it gets to the individual level, right? I can give you this general information, but then you have to think a little more closely about which assets you have, how they're owned, and how you want them to pass. If you have minor children, a lot of the joint owner options for bank accounts are not on the table because you don't want to make the joint owner passage your minor child. But if you have kids that are in their 40s or 50s, then that might be a different discussion. If you have a child with special needs, that's a bigger discussion because you don't want to leave assets directly to that person if they're receiving public benefits. It might make them ineligible for those types of things. So that's kind of the more personal level of consideration. The other thing to think about, and I always note this for clients, is I get lots of people that come in and say, oh, my adult kids are joint owners on all my accounts. And I have to be a little more cautious about what they mean by joint owners. Sometimes they say my kids are on my account. And to me, that could mean two very different things that people aren't always aware of. Because a lot of people just go into the bank and say, add my child on. At the bank level, your child could be a co-signer, which means they can see your account, they can access it, they can sign checks on your behalf, pay bills, things like that. But when you die, that asset does not pass to your child because they are not a co-owner, they are a co-signer. And sometimes it means your kid is a co-owner, which looks exactly the same as a co-signer while you're alive. Access to the account, can see it, can write checks, can pay bills. But when you die, that account moves to the co-owner and is owned by them without having to go to probate. So they look the same here, but they have drastically different consequences after you've passed away. So that's one of the things I always require my clients to do a little more digging on is, how is your child actually on your account? Are they a co-signer or a co-owner? Because what I don't want is for you to assume that they're co-owners on everything and then have them actually be co-signers, and all of those assets now are subject to probate, and you didn't prepare a will because you thought that they were all passing in that fourth box over here that didn't need the probate. Go ahead and go to the next slide, please. All right, this is the big meat of the discussion for taxes. And I know everybody's eyes start to kind of glaze over a little bit when I start talking about taxes, but this is a really important one for a lot of people that are Oregon residents. So I'm going to talk first about the federal piece of it. Federally, there is an estate tax law, and it says that when somebody dies, we add up all of their worldwide assets, and if that value is more than their federal exemption amount, then we tax the excess. And that federal exemption amount has been all over the board, like $600,000, $1 million, $3.5 million, $5 million. Well, now it's 12.92 million per person. So a lot of people are not concerned about that, because not only do they have almost 13 million tax-free passage themselves, married couples have what's called portability, which means if my spouse passes away and gives me all their assets, I also get their exemption amount, so that when I die and go to pass things to our kids, I actually have almost $26 million of estate tax allowance before I have to start paying any taxes. That's a huge benefit. Now look at bullet point number 3, which is that amount is set to sunset in 2025. We don't know if that's going to happen or not, right? Lots could happen between now and 2025, but if it does sunset, then it's going to drop back, most likely, we don't know again, most likely to somewhere between like 5.5, maybe 6 million per person. That is a big deal to a lot of people, because while they have 26 million as a joint couple right now, they would only have 10, 11, 12 million as a joint couple in 2 years. And so lots of people are choosing to do gifting right now, where they're saying, I want to take advantage of my high taxable federal limit now by making lifetime gifts. I file a gift tax return, it eats into my federal exemption, and then I don't care, because I'm going to lose it anyway, or lose some of it anyway in just a couple of years. Now, if you're thinking about doing lifetime gifts, I definitely want to encourage you to talk to an attorney and an accountant about it, because there are lots of considerations, basis considerations and tax all sorts of things. So don't just take this, I guess I would say take this with a grain of salt. This is a general discussion, not specifically geared to you. Lots of people are also in anticipation of this sunset provision in 2025, considering more charitable gifts, because they can gift to charities continuing on, regardless of what that federal exemption amount is. Excuse me. And charitable gifts decrease their estate tax burden after they pass away by lowering their total worldwide asset calculation. So that's what the federal picture is. Next slide talks about the Oregon picture. Oh, almost next slide. So this talks about a little bit more about the federal one. That's all right, go ahead to the Oregon one. The Oregon one is very, very different than the federal one. The Oregon one says the same thing. The Oregon law says when a person dies, we're going to take a snapshot of their worldwide assets and add it all together. And if it's more than their Oregon individual exemption, then we go ahead and tax them on the excess. In Oregon, your individual exemption amount is 1 million. And not only that, but if you're in that married couple situation where one spouse dies and leaves it all to the other, the surviving spouse does not get automatically the deceased spouse's exemption. There is not natural portability. And so that's a really important thought for a lot of my clients who are between that $1 and $2 million mark, based on real estate values and retirement values and things like that, where they're saying, oh, it's no problem. Between the two of us, we each have $1 million exemption. We have $1.7 million. And so we'll pass it tax-free. And I say, well, not really, because what happens in practice with no actual tax planning involved in your documents, what happens is first spouse dies, passes it all to the surviving spouse. Surviving spouse uses that during their lifetime. And then when they die, let's say they still have $1.7 million, they have a $1 million exemption. And so we get the first million tax-free, but that extra 0.7 is going to be taxable in their Oregon estate taxes at a rate of about 10, maybe 11%. It's a graduated rate. So that's something really important, right? Having $70,000 of taxes owed is something that we want to prepare for. And so that's where, again, a lot of charitable gifting comes into play, right? So when we calculate what your worldwide assets are, A lot of times we want to make that reduced by what you might give to charities, right? Those are not part of it. And things like that. There are ways that we can look at reducing your taxable worldwide assets so that when we go to calculate that, it's less burdensome. You can also look at what's called disclaimer planning. And disclaimer planning, go ahead and go to the next slide actually before I jump into disclaimer planning. This gives you kind of an idea of the tax rates for Oregon. So I said it, I usually quote people about 10%, but it does go up. I mean, all the way up to 16%, but 10 to 11% is most people's tax burden on that excess over their individual exemption. And then go ahead and go to the next slide. Yep, there you go. So individual planning, we look at lifetime gifts. That's one thing that we've talked a lot about, right? If you're every year you have a pattern of gifting, making a certain amount of gift to these 5 charities that you love, that's a great way to lower your taxable estate options. You can also make gifts after you pass away. So lifetime gifts would be an annual type of thing. I do it every year on January 1st. Some people just put that in their estate planning documents and say, I want to give, $15,000 to these 3 charities after I've passed away. Those are all options and great ways to lower the potential tax burden. When you are spouses, things that you can think about, you can split your lifetime gifts. You can use federal portability. You can do lots of charitable giving. You can do marital deduction trusts or disclaimer planning. And I underlined that one because that one is used usually in conjunction with a lot of the other ones. So I might talk with a client and say, okay, let's set up a pattern of doing these annual lifetime gifts that will help reduce your estate. Let's also include disclaimer planning in your documents. It's not a requirement. It doesn't lock you into anything, but what it does is it opens up the options for the surviving spouse after the first spouse has passed away. So it's a way of the surviving spouse saying, I've received these assets. Before I exercise some control, I want to think about separating some out, disclaiming it so that it doesn't become mine, and maybe keep it in the name of my deceased spouse and apply their exemption to it. So there are ways that you can kind of make it available for surviving spouse, but then maybe utilize both spouses' Oregon exemptions so that we can raise that limit of tax-free passage from 1 million up to 2 million. Those are all things that you can't do just on your own. So that's where I recommend sitting down, talking with an accountant about your charitable giving, talking with an attorney about adding disclaimer planning. Those are all things that need to be incorporated ahead of time. I get lots and lots of clients who have moved here from Florida or California or places that followed the federal exemption, and then they moved to Oregon, and I've got to do all of this extra tax planning that wasn't there before. So I've got a slide here to kind of wrap, and I'm wrapping up towards the end here because I want to save time for some questions, but I've got this slide here on planned giving. And it's a way for philanthropic individuals to make charitable or gifts to charitable organizations on their death. So this is less in the annual giving, right? I continue to give each year because I'm lowering my basis and I have these charitable inclinations. But this is more giving that happens after you've passed away. And usually I like to work with the charity as a way of saying, let's make sure we get all the language in here that you want, and we've titled everything correctly. And we want to make sure that, we're looking at the specific language, specific bylaws, all those types of things, and then section off a portion of your assets to go to a charity. Another way lots of people do it, and this is on the next slide, is to do some sort of distribution from retirement accounts. Lots of people choose to say, I want 25% of my IRA or my retirement, 401k, IRA, those kinds of things, to go to this charity. And I want my other assets to go to my kids or whatever it is. There are ways there that we can play around with the different assets to really achieve some huge tax benefits, because just charitable gifts are beneficial for estate taxes. And so lots of people include those as part of their overall planning to help minimize that liability for kids. The reason that IRA distributions are a popular one is because IRA distributions to a beneficiary are taxable income, unless it's a Roth, right? Taxes prepaid, are taxable income to the beneficiary. But if you've got a charity, then we've got a lot of exemptions there that wouldn't be allowed for an individual. So if this is something that you are, thinking about, or you're considering your different tax options and you've got these philanthropic ideals, I really recommend talking to somebody about what options best suit you, because there's lots of lifetime options. There's lots of testamentary after death options that can really help reduce or minimize those tax burdens that people have, especially here in the state of Oregon. So the last couple slides that I've got 2 last slides here, and these really talk about common mistakes and things that I see people doing all the time when I say, man, I really wish you would come in and talk to me, or gone and talk to an estate planning attorney, because we could have made some changes that really would have benefited you. So common mistakes I see: trying to fit all your assets really neatly into that box number 4 without including other things like your house. Naming all of your children as co-trustees. If you have 4 children, please don't name them all and require them all to work together, because every time they want to pay a bill, they're going to have to all 4 of them sign, unless you've got some special language in there. So that's a really big thing that I try to avoid as much as possible. Number 3 is one I see all the time. I've been meaning to come in and see you for the last 20 years, but I didn't have anybody that I wanted to name. And so I just kept putting it off. Well, at some point, we're going to have to name somebody, right? Leaving assets outright to a beneficiary who's receiving public benefits, or maybe isn't super financially responsible. Those are things that we can really amend and put in some special provisions to help smooth the path to make that a lot easier. Next slide. Not updating your estate plan after major life changes, marriage, divorce, significant asset changes. If you win the lottery, if you're really wanting to do some additional gifting, those kinds of things are all really big issues that we should address. If you have a child who's a minor and now was a minor and now no longer is, if you have more children, if you have grandchildren, all those types of things are reasons why you should pull out those estate planning documents and take a look at them again. The next one, forgetting about your trust. If you have a trust, go back, I'm not quite done. If you have a trust and you have titled everything in it, please don't be the person who 5 years later buys a beach house or opens up a new bank account and forgets to put it in the trust name. That's the worst case scenario of the trust, and I want to avoid that as much as possible. Giving the named personal representative or trustee verbal instructions about what you want them to do, like, hey, when I die, make sure that you give $5,000 to each of those charities I like. That's not legally binding. We can't enforce that. Or make sure that you take care of the grandkids. Those things are things that you should be including in your documents in black and white. And then my last one here is do-it-yourself planning, right? If you have minor children or a blended family or real property, especially in multiple states, and really any of the things we've talked about at all, tax planning considerations, those are reasons you should be going to see an attorney to make sure that all of you kind of crossed all your T's and dotted all your I's. So I'm going to stop there and go ahead and see if we've got any things in the Q&A that I can answer. And like I said already, if I don't get to all your questions, my email address is here. You're more than welcome to email me and ask me any questions you want. I'm happy to answer those. I see that I accidentally put 2 email addresses on there. Don't use the bottom one, use the top one. Emily H at Fitzwater Law.
Thanks so much, Emily. You do such a good job of simplifying a really complex topic, and that's really daunting for a lot of people. So thank you.
No problem. And I know I do talk fast. So if there's something you missed, feel free to reach back out.
Yeah, we tried to fit as much as we could into this hour. So if you do have questions, please put them in the Q&A box, and I'll post some of them to Emily right now. So Dolores has a question, and I think this was submitted when you were talking about wills specifically, Emily, or maybe not having any estate planning document in place. What if you have no spouse, children, or relatives? What happens to your assets?
Good question. So the laws of intestacy have kind of a long list of if you have A, it goes to A. If you don't have A, it goes to B. If you don't have B, it goes to C. So spouses are usually first, unless it's a blended family situation, then a portion goes to spouse, portion goes to your kids. Then we continue on. If you don't have a spouse, if you don't have kids, it usually goes to well, first it looks to see if you've got parents. If you don't have parents, it looks to, I'd have to look at the statute, but I think it goes siblings, then maybe nieces and nephews, aunts and uncles. It just kind of continues on down the line until they find somebody in your extended family.
Great, thank you. So this is a little bit more specific to one individual situation, but it may, apply to others. A married couple married later in life, and one of the spouses has 2 grown children. And so how do you advise individuals to think about taking care of their grown children while also making sure that the surviving spouse has some assets in place? And that's very succinct. So I'm sorry if I didn't touch on all of the parts of that question to the submitter.
This is actually a really common scenario. And there are lots of things I would want to talk to the couple about specifically. We'd want to do planning for the 2 spouses together to make sure that everybody's on the same page. But usually it entails kind of one of 2 options. Option 1 is to say, I'm just going to leave everything to my spouse, and maybe a portion of beneficiary designation assets, like my retirement, will go directly to my kids. And then, at the death of my surviving spouse, his or her document will direct some of that back to my kids. The other option is to force a split where it says, I'm going to give X percentage of my assets to my spouse and X percentage to my kids. And then that way my spouse can do whatever she wants with his or he or she wants with his or her share. My kids have already received their share. That's the safer option, but it also has the potential. What if your surviving spouse needs more money for care or something like that? So there are a lot of considerations about which one suits your needs best. And also which types of assets you have. If you have a lot more of your assets is concentrated in real property, that might look different than if it's concentrated in retirement accounts, because we want to make sure that the spouse has somewhere to live and those kinds of things.
Great, thank you. This question, I have a living trust. How do I designate real estate in the trust?
Yeah, so it's just a deeding process. Where, like, for instance, if Emily Hogan owns my house and now I create a trust, I have an attorney prepare a deed that says Emily Hogan, grantor, devises and warrants the real property located at whatever your legal description is to Emily Hogan as trustee of the Emily Hogan Trust. And then that deed gets recorded with the county where the property is located, so that now the official record, instead of showing that the property is owned by Emily Hogan, it shows that it's owned by Emily Hogan's trust. But I still control it because I'm the trustee of the trust. So if I want to sell it and buy a new property, I just sign the sales documents exactly as I would as if it was an individual.
Great, thank you. Someone on the webinar has a charitable remainder unit trust. And so I'm not sure the exact question, but can you talk about maybe any tax considerations or anything that someone with a life income gift like that might consider?
Yeah, so let me preface this by saying there are lots and lots and lots of different types of provisions that can be put into a charitable remainder trust. So without seeing your specific one, I don't know exactly what the provisions say, but generally it's going to be something in the realm of, I put this money or sometimes property into this trust and I will receive income during my lifetime. Sometimes it's also my spouse or my kids after I've died will receive income from this trust. But after those designated beneficiaries have passed away, then that asset becomes owned by the charity. And there are huge tax benefits to doing charitable remainder trusts because, just like we've talked about, charitable donations provide you huge minimization benefits for estate taxes and income taxes. And in this type of situation, it's very, I wouldn't say flexible, but it's very attractive because it provides you with income or resources during your life. You're not gifting everything away and then having no benefit of those things.
Yeah, great. We did have a question about what is the difference between a gift and an endowment, and I can answer that. So when we work with individuals who gift, specifically Providence through their estate, we really like to have a proactive conversation with those donors to talk about how they would like that gift to be directed. And there are two main options. There's what we call an outright gift. So you include Providence in your estate for $10,000, and that goes towards a specific fund, and that money can be spent right away. And the other option is an endowment, where the funds are invested, and because they're invested, they will last in perpetuity. And so we use a lot of the spinoff from those investments year after year to then fund what you'd like to support charitably. That's very high level. And if you have interest in an endowment, again, I really encourage you to sit down and talk with one of us so we can discuss your specific options and make sure that we have all of the endowment language correct as you would like the fund to live on. So Emily, there was one other question. If someone wants to make an appointment with you, do you have an initial consultation fee? And can you also provide maybe a general fee for what a will or a trust may look like?
Yeah, good question. So I do not do free consultations, and I think that that's kind of the practice, just because attorneys generally are billed for their time. And just so you know, most attorneys bill an hourly fee, and they bill in 6-minute increments, so tenths of an hour. There is kind of a push, and I'm a big proponent of this, to do flat fee estate planning, where instead of me saying every time you email me or call me or every time I work on your documents, I'm ticking that 6-minute clock off. Instead, I say, well, where I was billing hourly, I'd give you a range of $2,500 to $3,500. I'm just going to tell you it's going to be $3,000, and that's a flat fee. And that's going to include all my time that I work on your documents and our meetings and your emails and phone calls and the signing appointment and the witnesses and the notary and all that stuff. I'm not going to bill you every 6 minutes for those things. I'm a big proponent of flat fee billing because I was finding, especially with young families, that I would bill them in my hourly normal way, and they'd go through the whole process, sign their documents, and go on their way. And then they'd be trying to update their life insurance beneficiary designations, and they couldn't quite remember how to title the testamentary trust for the benefit of their kids, but they didn't want to pay me anymore. So they wouldn't call me and ask me. And for me, that's a huge deal, because as you probably figured out from this presentation, all those pieces of estate planning all work together, right? If I do this beautiful will or trust for you that holds your kids' money until they're 25, and we've got a trustee and all this, but then you have a $500,000 retirement policy that leaves it outright to your kid, then we've got two separate estate plans that say totally different things. And so I really want to encourage people to call me and ask those questions. And so 95% of the time, I flat fee bill my estate planning, where at the end of the first meeting, I say either, I say, do you think you want to go forward? And if they say, no, I don't think we do, or today was just information gathering, then I just bill them hourly for that hour and a half that we were together and move on. But if they say, yes, we definitely want to do a will package, or we definitely want to do a trust package, or whatever it is, I generally then flat fee bill it. And I say, okay, it's going to be, $3,000. And that includes today's meeting, no hourly for today. And it includes all of the process that we're going to do. So it's all wrapped up in one fee. For general quotes, it's pretty hard, because if I've got a single person, that's way different from a couple, right? A couple's going to be 2 of all the documents, but it's not double the cost. And if I have a couple that has less than $1 million total, I'm not going to do any tax planning, but somebody who has $2 million, I'm going to do a lot of tax planning. And so it was really difficult, but I'd say, I don't know, to give you a rough estimate, will packages probably range from $2,000 to $4,000. and trust packages are generally about $1,000 more. And again, that all depends on your assets, the complexity of your estate, whether you have minor kids, all of those kinds of things. That is something though that I could easily, if you wanted to shoot me an email with some particulars, I could easily narrow that down much, much more for you.
Great. Thanks, Emily.
Yeah.
I think those were all of the questions that I saw. We will be sending out a recording of this webinar by tomorrow, so you can rewatch at your convenience or look at the slides and pause. But I do want to thank you again for joining us today. Again, many of you are donors on this call, and we're so grateful for your support. If you would like to talk a little bit more in depth about charitable planning with your estate, please let me know. We really are here to be a resource and to make sure that you have all the options available to you as you're going through the planning process. And if you would like a copy of our estate planning guide, make sure to email me at megan.crane@providence.org. And with that, thank you again for joining us today. And I hope you have a great rest of your afternoon.
Thanks, everybody.